All right, we are live and recording.
Morning, welcome to the Appeals Court. I am Justice Meade. With me this morning are Justices Wolohojian and Massing. We'll be the panel for your case. Each side is permitted 15 minutes of argument. You needn't use all of your time. We do not entertain rebuttal. With that, I will call the next case. 2020 P1175, Commonwealth versus GEBO. Ms. Rumilitis.
Good morning. I represent Elizabeth GEBO. So I'm going to assume that the court is familiar with the details of the case. I'm going to just jump in on the first issue, which is the jury waiver issue. At the trial readiness hearing, the defendant had indicated at that point that she was going forward with a jury trial. And her attorney said, at this point, yes, that's the plan. And the court said, okay, be subject to a motion when it's called for trial next week. Thus presupposing that the option for her to then waive the jury trial was possible at when the trial actually began, which is what she did. On the morning of the trial date, she filed a Rule 19 motion wanting to waive the jury trial. It was not allowed, which is why we're here. And the reason was that the judge indicated that she didn't provide good cause for her waiver. The various rules that apply to this situation, of which there appear to be many, all can be read consistent with one another and consistent with her request. The rules essentially say, and the rules I'm referring to are Chapter 263, Section 6, Mass Rule of Criminal Procedure 19, the District Court Rule of Criminal Procedure 4, as well as the supplemental rules for the District Courts, Rule 10, all throw in different bits of how to do this, and they can all be read consistently with one another. Essentially, the rules indicate that as long as she requests a waiver before the trial starts or before the jury is impaneled, she can request that waiver. A waiver can't be asked for by a judge prior to the completion of discovery.
Can I interrupt for a second?
Of course.
The Commonwealth says that Rule 4E and 5 says you have to make that election when discovery is done, and you can't, and after that it's untimely. What's your answer to that?
I don't read the rule that way. The first rule 1 of those particular rules that apply to the district court indicate that, as long as the various rules are consistent, let me say this differently, that the district court rules apply unless there's an inconsistency with other rules. I don't read Rule 4 as being inconsistent with either Rule 19 or Section 6. Rule 4 says, it says after the pretrial conference report is submitted, assuming discovery is complete, the court shall inquire if the defendant waives the right to a trial. And if jury trial is not waived, the case shall be scheduled to a trial. But nowhere in that rule does it indicate that the defendant can't then also request that the jury trial be waived subsequent to that. I view it as the clock starts at that point, but the clock doesn't end at that point.
And since 263(6) talks about doing it as you can do it as long as the jury hasn't been impaneled, I think you'd tell us that the statute trumps whatever the rule says anyways, right?
You can say that the statute trumps it, sure, or you can read them as saying they're not inconsistent with one another, and we can read these rules as all applying and all leading to the same result, that the defendant can waive it starting at a certain point, and then there is eventually the end point, but the end point isn't at the pretrial conference. The end point is when the trial has started or the jury's been impaneled.
Can I ask an unrelated issue? How do we assess prejudice, and or how was the defendant prejudiced?
Yeah, it's an interesting question. The thing that I see here is that in this situation, I don't believe at all, and my argument at all is not at all that just because the defendant asked for the jury to be waived, that she should have just automatically been granted that. Rule 19 says that the rules contemplate a judge to say no to that request. Right. And Rule 19 says there needs to be good and sufficient reason. So what happens when the request is denied for something that is not a good and sufficient reason, which is what I view happened here? It was denied for, at best, the reason was to avoid judge shopping. And I don't view that as a good and sufficient reason, because essentially it's saying to the defendant, here you go, you have the right to request a jury waiver up until when the jury's impaneled. At that point, you're going to know who the judge is. So if a reason can be that you know who the judge is, how the defendant has no ability then to meaningfully waive the jury trial at that point. And so
can I, if the waiver had gone through and it went to a bench session, was there a bench session then operating in the same court, or was it going to go to another court?
I don't know.
Okay, I'll ask the ADA.
I mean, it seems to me your argument has got to be that you don't have to show prejudice, right? Because you can't possibly show prejudice. You can't tell that you got acquitted by a judge, but not by a jury.
Well, no, I don't think you can make that argument. But if the rules are to have any meaning, then the denial has to be done correctly. Otherwise, as in this case, it feels like it's just an arbitrary reason. So the prejudice stems from the fact that she had a right to make this request, and the denial can happen in a proper way, but it didn't here. And so
it would probably, the good cause would seemingly emanate from answers to the colloquy that the judge would have gone through with her.
I'm sorry, I missed the beginning of your question.
So I'm getting the good cause that is spoken of, I would think, is generated from whatever the answers are during the colloquy when the judge explains what waiving a jury means. For example, if she didn't understand X, Y, and Z at the colloquy, that would function as good cause. But we never got there.
Right. Well, right. Sure.
So I'd like to go back to the question of prejudice.
Okay.
Let's assume for these purposes that there was error here. And, there are all sorts of errors. They don't all result in reversal. So, right. So, but let's just assume for the moment that there was an error here. And I think I don't remember if it's Collins or Collado, but one of them says that this is not a structural error and that you have to have prejudice. So, and you don't argue that it's a structural error. And I think that's probably correct given the precedent. So if it's not a structural error and you have to show prejudice, what I didn't really see in your brief an argument as to what that prejudice would consist of here. Mm-hmm. And I'm thinking sort of analogously to the errors in, I had a case a while back where the defendant was erroneously deprived of the full number of peremptory challenges. And that also required a showing of prejudice. Both of these situations, it's hard if you have to show prejudice, but I don't think the test is that the case would have come out differently. But at the same time, there's got to be some showing. So what do you think the showing would be? And what do you think it is here?
I think here the showing is that it's a really tricky thing. It's, to me, I see it as the showing being that, you know, the ability to waive the jury trial has to happen within these certain rules, and it didn't for her. So the prejudice stems from the fact that her right to waive the jury trial was taken from her improperly, because otherwise we don't know what would have happened at a bench trial.
Isn't that arguing structural error?
I think it's sort of,
She has a right to a jury trial.
yes,
The right to waive the jury trial is not constitutional, right?
right. That's true.
The right to the jury trial is constitutional.
Right. And otherwise it's a hard thing, because otherwise it seems to me that that ability to waive ultimately becomes meaningless at the point of when you're trying to waive right before the trial begins, which is when, you know, because if any reason is given, regardless of the reason, and the judge says, no, you can't waive it now, for, I'll say no reason, or I'll give some arbitrary, meaningless reason, and then the rule requires a particular, you know, actual prejudice to be shown, then the defendant is left nowhere. I mean, at that point, there's nothing for the defendant to do, because
Is there anything in the record that would reveal that there was a change in the defense's strategy, because, or how they would have changed their strategy if they'd been able to go before a judge alone?
I don't have anything. I don't know. Yeah.
And she was acquitted of one of the ABDWs, right?
She was. Yes, she was.
Did you want to discuss your other issue briefly?
I can discuss that one very briefly. The other one was, you know, the dangerous weapon charge. Was there sufficient evidence to prove beyond a reasonable doubt that this chair was a dangerous weapon? I will mostly just rely on my brief. I'll just say that there was no evidence introduced whatsoever as to the nature, the size, the real appearance of this chair, nor how it was really used. All we know is that it was
She swung it at him and hit him in the wrist, though, right? We do know that.
We know that he was hit in the wrist, and he had a, you know, size of an
2
abrasion.
square inch gash in his wrist, right?
Yes, we know, right. We know that there was injury. But we don't know that this chair qualifies as a dangerous weapon capable of producing serious bodily harm based on the description that was offered at trial. Nor do we know how, in fact, this chair was used. I mean, other cases talk about chairs being, you know, slammed over somebody from above, or, you know, various strength being used for these things. We don't know anything here other than what the jury viewed from the, you know, the defendant in terms of her appearance at trial.
Okay.
Unless there are any other questions, I will stop there.
No. Seeing none, thank you very much.
Thank you.
Mr. Wendell.
Yes. Good morning, and may it please the court, Assistant District Attorney John Wendell for the Commonwealth. Turning to the issue of jury waiver, first of all, the statute 263 section 6 doesn't actually give the defendant the right of waiver unfettered in this particular case. The rule, I apologize here, I'm reading, except where there is more than one defendant involved as aforesaid, consent to said waiver shall not be denied in the district court or the Boston Municipal Court if the waiver is filed before the case is transferred for jury trial to the appropriate jury session. This case had already been transferred for jury trial to an appropriate jury session. That was done. So Section 6 does not apply here in terms of requiring the judge to allow this waiver.
Well, Mr. Wendell, if the judge had said that, then I would agree. But he did not say that. He said she hadn't shown good cause, so he's put the burden on the wrong person. And he notes the defendant's objection, so the issue is preserved.
The issue is preserved, Your Honor, but the statute does not grant the defendant the unfettered right to waiver. Rule 19 does not grant the unfettered right to waiver. It requires a showing, it is true, it requires a showing by the court of good cause. I will agree that based upon what the trial judge said, it appears he somewhat misunderstood the application of Rule 19.
Yeah.
But I'm reminded rather forcefully of the other cases that this court and the Supreme Judicial Court have decided, where it's remarked that we affirm the decision, but for different reasons. I would suggest it is appropriate to affirm the judge's decision, to rule that the judge
my point was only that you made a significant argument that the request was untimely.
It is untimely, Your Honor.
Which would mean that it's substantial risk or something for the analysis. But since he preserved the issue, then that was not as I know what you're saying. That he maybe was right for the wrong reason.
I guess perhaps calling it untimely was, well, it's a bit odd, Your Honor. There's timeliness and then there's timeliness. There's timeliness in terms of timely so as to preserve the claim of error, but there's also timely as in you have a chronological obligation to do things by X date.
Thank you. I've been trying to interject, but my audio must not be working well. I don't think the defendant is arguing that she had an absolute right at any time to claim a bench trial, to waive her right to jury. And I don't think that your argument is correctly phrased as timeliness, although that's what you use. What you're really saying, I believe, is that up until a certain point, the defendant does have an absolute right to waive the jury trial, and that occurs until the case goes into the jury session. Because the statute says the judge shall grant that request, and therefore that's a mandatory obligation on the judge. What happens thereafter, I believe you would agree, but correct me if you're wrong, is that the decision is discretionary on the part of the judge, correct?
That's correct.
All right, so that's not really about timeliness. That's about the standard that beforehand the judge must grant, and then after that the judge has discretion. Here, Judge Meade pointed out, the discretion appears to have been incorrectly exercised because the judge placed the burden on the defendant. You would agree that the judge articulated an incorrect standard for assessing the request?
Only sort of, Your Honor. Rule 19 does say grant waiver unless there is good cause. And that suggests that the court must find good cause not to grant waiver, as opposed to requiring the defendant to show good cause why waiver should be allowed. But in this particular case, I would suggest that the supplemental rules give the trial judge good cause in and of themselves to say, no, we're not going to do this at this point unless you give me a reason otherwise.
So if the judge relies, as the judge's explanation is, I want to deter the appearance of judge shopping, which in the abstract, let's assume is a good reason, okay? But we don't assess these cases in the abstract. What is there in this record to indicate that there was judge shopping going on?
I don't know that there is anything, Your Honor.
Were you able to answer Judge Meade's question from that was asked to your sister about whether the bench trial, what would have been heard before the same judge, or whether it would have been transferred to a different session if it were a bench trial?
I believe it would have been heard before the same judge. So far as I know, that is the common practice in Springfield District Court. A matter is sent out to a judge for trial, and that judge either conducts the bench trial or impanels the jury and proceeds.
Okay,
It
well,
seems to really undercut the inkling of judge shopping then.
I would actually say it reinforces it, Your Honor. You know which judge, if you are allowed to know which judge you are going to be before you decide whether to waive the right to a jury or not, then I would suggest that indicates that this is entirely judge shopping.
all right, but can I say the cases are clear that we understand the right to waive, the ability to waive a jury trial to be strategic for that very reason. And we understand that that's the reason why the decision is made. And so how does that constitute, how can you square the notion that simply knowing who the judge is going to be constitutes judge shopping?
Your Honor, I would say that more of the cases, strategic reasons for deciding to waive have to do with, it's a particularly complicated issue, a technical issue that the jury may not understand the technical nature of the case, and it's more a legal dispute than a factual one.
Doesn't judge shopping infer that you're looking at an alternative, or you're at multiple judges, more than one judge, and trying to get your case in front of one rather than the other?
That is one way it can happen, Your Honor. I would say another way in which it happens is that there are, at any given time, there are multiple judges sitting in Springfield District Court. It is one of the larger courts of this Commonwealth. And so there are multiple different options. Some may be favorable to the defense, some may be more favorable to the prosecution. If a defendant is permitted to wait until they find out which of those judges they have before deciding, I'll have this as a jury trial or I'll have this as a bench trial, then they're permitted to find out if they have one of those defense-friendly judges before making their decision. And I would suggest that is judge shopping, if not in quite as blatant of a way as some other cases.
I have difficulty understanding that other than as a strategic decision between jury and bench, if there's only one judge involved.
Well,
in any event, can you talk about the question of prejudice?
Yes,
and why is it, and how is it in any case that how would a defendant ever establish prejudice for this kind of error? Can you give us a couple of concrete examples?
Sure, Your Honor. As I said, I think to some extent the question of strategy in terms of jury or bench trial comes down to cases where it's a question of credibility versus it's a question of law and technicality. And there are cases where a matter is particularly emotional and rather confusing. For example, I recently had before this court an appeal on an OUI manslaughter case. There was no question the individual had driven drunk. There was no question the death had occurred. The question was whether the action constituted manslaughter. And that's, given the fact that it was a homicide, the emotional nature of the case makes the decision to go with the jury trial rather fraught. And the defendant in that case ultimately went with a bench trial because of the very technical nature of the case. In that case, had the defendant said, well, I was worried that the jury was confused or would be confused, but the judge denied my request for a bench trial, I would suggest that that's a case where prejudice is obvious. There are others.
You don't think there's an emotional aspect to a septuagenarian couple combating with chairs?
I'm sure there is to some extent, Your Honor. There's an emotional aspect to every case, but the point I was making, it's not the emotional aspect, it's what precisely the finder of fact has to determine. If the question before the finder of fact is, did this happen or didn't it, then I don't think there's any way to show prejudice between a jury trial and a bench trial. When the question is, how do we understand what happened, there might be. This is a case, did this happen, did it not? Do we believe the victim or do we believe the defendant?
Attorney Wendell, what is your best case for arguing that the defendant has to show prejudice in this situation? Because this isn't Collado. Collado, the defendant actually got their jury waiver.
Well, Your Honor, I would simply say this is not structural error. The decision.
What's your best case for that? Collado?
That's probably the best case, yes, Your Honor. But it's a simple statement of law. I don't know that that particular aspect changes one case to another. If it is not structural error in one case, then it is never structural error. And if it is not structural error, then the defendant must show concrete prejudice. And
well, the problem simply Collado, the defendant got what she wanted, and then she was arguing, I shouldn't have been given what I wanted. Here, the defendant didn't get what she wanted.
Yes, Your Honor, that is true. But the point remains, the question of waiver or not and proper waiver or not is not structural error. And that, I guess this, I mean, maybe it has not been addressed many times, but the only times it has ever been addressed, it has been determined as not being structural error. Not being structural error, prejudice must be shown. There is no prejudice shown in this case.
I know Justice Wolohojian asked you, but I'm still stuck on how do you view a defendant's burden to establish prejudice in these circumstances? How would they do that?
Again, Your Honor, there may be circumstances where a particular strategic decision could be stated. Had I gone bench, I would have done X.
But there was an obligation to make some sort of proffer or offer of proof, right?
Yes, Your Honor. That, at the minimum, some sort of proffer from the defense attorney. Your Honor, this is interfering with my strategy. I had intended to do one thing. That didn't happen here. What we had was, I want to go bench because we decided that. Like he was very vague, didn't even attempt to suggest to the court anything. There was no post-conviction motion, which might have permitted fact-finding on the subject. So there simply is no showing of prejudice in this case.
Do you want to say anything briefly on sufficiency?
I have a question. I have a specific question about her, actually. On page 30 of your brief, you say that the defendant admitted the chair had sharp edges and was capable of causing injuries. There's no citation to the record for that, and I didn't find it in the record. Could you tell me where in the record that is?
I apologize. It's earlier in my recitation of the. During her own testimony, the defendant made some comment about how when the victim grabbed the chair and pulled it away from her, that it cut her hand and she required stitches. That was
okay. Thank you.
I forget. It's in the statement. It's in the statement of the facts. I forget the particular point in the record, and I can't find it at this exact moment. But that was what I was referring to. I apologize for not properly citing to that. Otherwise, the only thing I would say about the sufficiency of the evidence is that the defendant's argument is basically, this did not cause injury here. It was a small object, so therefore it can't have been a dangerous weapon. But small objects can be dangerous weapons, and whether something is dangerous as used is primarily for the fact finder to determine. That's really all I have time to say at this point. I see I'm nearly out of time. Unless there are further questions, I would rest on my brief.
Thank you. Thank you both. We'll take this under advisement.